Drake for quite a long time. I've reached the point at which I discover that students I have are the sons and daughters of students I had originally. Feeling a little long in the tooth, but that's all right. You know how students are. Kids, their idea of history is yesterday morning at the earliest. So that is an issue sometimes. I was very pleased when John contacted me about doing this. For about a dozen years or so, I've been serving as one of several scholar consultants for a group called the Bill of Rights Institute in Washington, D.C., and they put on constitutional seminars, and I've done quite a number of those, and typically, not sure how yours works, but they typically have a day. We come in the night before, and there's somebody from the Institute, and there's a scholar, and the scholar will present three over the course of the morning and then early afternoon, 3 45-minute seminars on whatever the topic that's being funded. I've done religious liberty, I've done presidential power, I've done due process, Bill of Rights, things like that. And then the scholar, then the Institute person will do what I guess your fellow from Simpson will do, is say, okay, here's how to use this in the classroom. So this is very similar to the sort of things I've done. So I was very happy to do this. And, you know, I always say to high school teachers and middle school teachers, thank you. I could never do what you do. I mean, they're just hormones on wheels. And I don't really want to deal with all that. But somebody's in the trenches, and that's you all. So all honor to what you do. What I want to do this evening, just in terms of credibility, if it matters, when I talk about these things, what I'm trying to do is avoid sort of getting us into quicksand, because two of the books I've written have to do with, one, constitutional interpretation, and two, the religion clauses in particular. My most recent book is called The Constitution of Religious Freedom, God, Politics, and the First Amendment. So I tend sometimes to stay on the edge of the precipice, trying not to dive in too far, because that's not something that would be fair to subject you to at this point. But as I looked at the title of Unit 5 on the Bill of Rights, I thought what I wanted to do here is not give you sort of a walking encyclopedia or a dictionary definition of each of the rights in the Bill of Rights. The materials are there in the book I saw that you have. It's a pretty good book. But I want to raise some broader issues of principle and interpretation and questions about understanding the idea of the way individual rights, constitutional rights, work in our system. Because, in fact, the description in Unit 5, the Bill of Rights protects freedom of religion, freedom of expression, right to privacy, and numerous procedural rights of the criminally accused. This unit begins with an exploration of the concept of rights, what they are, their categories, and the relationship of a democratic government to rights, so on and so forth. The focus is very much the Bill of Rights, but that begs a certain question. In other words, begs the question of, well, where do we get rights? Where do we find rights in the Constitution? Because American life is complicated, of course, as you know, by the fact that we have 51 separate legal systems in this country. We have 50 state legal systems, and we have the federal system. And at least as far as I read here, it doesn't really raise that issue, so I will want to get into that issue. I don't have a PowerPoint for this, but I can give you, just to tell you that there are 4 principal topics I want to talk with you, not lecture at you about this evening. The first is, what is a right? The second is, what constitutional rights do we have? The third is the Bill of Rights, and each topic raises all sorts of subsidiary questions. And the fourth is the 14th Amendment, because you can't talk about constitutional rights without talking about the 14th Amendment. Okay? And let me begin by asking you a question, which you may think is completely off the wall. But if you want to keep somebody from speeding in a car, and I know nothing about the way cars work, I just pray it works when I stick the key in. There are 2 principal standard ways you can keep somebody from driving a car faster than you want the person to drive it. Can you think of what they might be? I'm sort of asking you to read my mind, but
the manufacturer can set a so it doesn't go past a certain speed.
Right. I think they used to call that a governor. Right? In other words, you can design the car in such a way that even if the driver wants to speed, the car simply can't. It can't go above a certain speed. Okay? What's the other way? And it's so obvious and normal you may not notice it. What's the other way you keep people from driving faster than you want them to drive? You put up a speed limit sign. Right? You put up a speed limit sign. Well, in a sense, according to Madison and Hamilton and people like that, and I'm putting these words in their mouths, but I think with fairness, the idea of a right is like putting up a speed limit sign. Okay, you tell somebody don't do something, and you penalize the person if he does do something. But you recall that in the original Constitution, there really wasn't much in the way of rights. Their idea of how you protect individual rights was analogous to the governor in a car. In other words, you design the constitutional system in such a way that even if somebody wants to abuse powers, you can't do it. Okay, so they were going to take care of protecting individual rights through designing the Constitution in such a way that you can't abuse powers even if you want to. As you know, there are all sorts of faulty quotes that go around, like, for example, you can't shout fire in a crowded theater. Oh, yes, you can, right? You can't shout fire falsely in a crowded theater. But if there's a fire, you sure as hell better shout fire, right? But the other thing is the Constitution was created to limit the powers of the national government. That is simply false. Okay? We already had a national government of severely limited powers, the Articles of Confederation, right? And everybody that went to Philadelphia, including those who backed the New Jersey plan, who opposed the adoption of the new Constitution, everybody, both sides agreed the national government needed more powers. Right? The only question was whether you could give it the powers it needed within the framework of the Articles of Confederation. And those that backed the New Jersey plan said, yes, you can. And they became the anti-federalists opposing adoption. And those that said you can't give the national government the powers it needs within the framework of the Articles, you've got to get away from that and create something brand new. They were the ones that supported the adoption of the Constitution. But they all agreed the national government required greater powers, so the Constitution was created to increase the powers of the national government with the proviso that there's got to be a way to make sure that the government didn't abuse those increased powers. And the way they set about attempting to provide that guarantee initially was not through the idea of rights. It was through the idea of constitutional design. I'm hoping you can see this. You don't have to see it in great detail against the light there. But, this is, obviously Article 1 creates the legislative branch, Article 2, executive, Article 3, the judicial. Article 4 is what I call the interstate relations article. I may touch on that tomorrow. We talk about citizenship. Article 5 is sort of a grab bag, although, that's the amending article. Article 6 is a bit of a grab bag, although it contains something very important, the supremacy clause. And Article 7, the ratification procedure. But that was the original Constitution. And in fact, their big concern, if you recall, was, despite the fact that they experienced what they took to be the tyranny of the king, although if you read the pamphlets from the 1760s and the early 1770s, the big, awful actor in the whole process as far as the colonists was concerned was not the king, it was the Parliament. It was Parliament. But nonetheless, if you look at the Declaration, they mentioned Parliament once, but you have that whole bill of indictments against the king. That was the focus. But in the 1780s, they had enough experience of state legislatures in which, by the time the Constitutional Convention rolled around, they decided that, no, a legislature could go off the rails and get out of control as well. And so in the original Constitution, I've never done the checking myself, but according to an article I read, respected scholarly article, 40% of the text, the words, the verbiage of the original Constitution was Article 1 on Congress. The entire rest of the Constitution, the other 60% of the Constitution was Articles 2, 3, 4, 5, 6, and 7. So the bulk of it, a big chunk was Article 1. But you'll recall that Article 1, Section 8, which is what I have up there at the moment, is the grant of powers to Congress. Article 1, Section 9 is powers prohibited to Congress. So if you look in there, of course, the first clause has to do with the slave trade. The second and third clauses are a kind of right? The privilege of the writ of habeas corpus shall not be suspended unless when in cases of rebellion or invasion the public safety may require it. No bill of attainder or ex post facto law shall be passed. Those are rights, if you will. But the rest of these aren't really rights. Okay, they're procedures. You can't have a title of nobility. I always tell my students that if Congress, in its wisdom, decided to name me Dennis, Duke of Des Moines, they can't do that because of this. There's a story. Some people claim it's apocryphal. Others say, no, it really happened. Do you remember when celebrity stamps came out? Some of you may be too young to remember that. And when I think the first might have been a picture of Marilyn Monroe. The second was Elvis. And what was Elvis's nickname? The King. And they were going to put that on that stamp. And they said, you can't do that because Congress may not bestow a title of nobility. Okay? So, these things come to play. But you see, in things prohibited to Congress, basically in terms of rights, they can't pass a bill of attainder, ex post facto law, and they can't suspend the writ of habeas corpus except under certain specified circumstances. Article 1, Section 10 lists things that are prohibited to the states. Okay, so Article 1, Section 8 lists the powers granted to Congress. Article 1, Section 9, the powers prohibited to Congress. Article 1, Section 10, powers prohibited to the states. Okay, and to a great extent, here, there's not much there either in terms of prohibitions on the states. Will we have access available tomorrow by any chance, John, a whiteboard or something I can sketch some things on? Okay, I don't need it now, but I will. Well, yeah, I will need that. We'll take a break in the middle of this, and I'll need it the second half. Okay, thanks. So you see, there's not much in the way of rights here. So the early idea was that the way individual rights or liberties, as they said, were to be protected was through constitutional design. Madison warned against mere parchment barriers, right? That's one of the reasons why they talked. Remember, there's this phrase in Federalist 51 from Madison: ambition must counter ambition, right? Or must be made to counter ambition. The idea was that with the separation of powers, you give people a vested interest in their branch of government. So congressmen, people in the House have a vested interest in the powers of the House, and Congress generally. People in the Senate have a vested interest in the powers of the Senate and Congress generally, as against to what the courts and the executive may do. And the executive has a vested interest in the power of the presidency, the executive branch, and so forth, right? One of the problems, though, is of course, political parties. Political parties weren't considered from the beginning, but they separated powers so well that you needed a way to bridge the institutional divisions. So that helped give rise to political parties. By the end of Washington's second term, the one grouping was around Jefferson and Madison. They were called the Democratic Republicans. And the other grouping was around Adams and Hamilton, who later went on to his own stage career on Broadway, evidently. They were the Federalists, okay, but different from the Federalists supporting the Constitution. It was a different use of the term. But that meant, say, if you're a Democratic senator with a Democratic president, on the one hand, you want to work with your Democratic president. If you're a Republican senator, you want to oppose a Democratic president. But on the other hand, if you're a Democratic senator with a Democratic president, or a Republican senator with a Republican president, what if one side encroaches on the authority of the other? On the one hand, the framers thought you would resist that, but on the other hand, with political party loyalties, they would counteract institutional loyalties. So that creates a bit of a problem. But in any case, they thought if you separate powers well enough, even if a branch of government wants to abuse individual liberties, they wouldn't be able to. Again, this idea of the governor. And the metaphor I use for my students to understand separation of powers in this regard is driver's ed. Now, when I was in high school 100 years ago, we used to have, I think kids have to take driver's ed privately, don't they? I mean, we used to have it in gym class. Of course, you'd have a hungover coach in the front seat in the driver's ed car, and you had your friend sitting in the back seat asleep, and you'd be there trying to stay on the road. Okay, but I tell the kids, what's different about a driver's ed car? Well, of course, the person riding shotgun has a brake. And in a sense, the president has the bulk of executive powers, but Congress and the courts have a brake. The courts have the bulk of judicial powers, but the president and the Congress have a brake. And Congress has the bulk of legislative powers, but the president and the courts have a brake, which explains gridlock over the past 8 years, right? But this was the idea that the driver can't get abusive and go wild because the other two branches have a brake, okay? And that's their idea, to mix the metaphor of a governor on the engine or this sort of thing. The constitutional design was supposed to prevent government from abusing its powers and infringing upon or threatening individual liberties. But of course, you know from your American history, and I imagine some of you may teach it, that one of the big complaints about the Constitution was that there was no Bill of Rights, and a condition of ratification in many states was the first thing Congress will do, will pass a Bill of Rights. By the end of the I have to tell students, college students even, by the end of the 19th century, people began to think of the Founding Fathers as these moral and intellectual giants who bestrode the world and gave us this wonderful document. And I tell students, the adoption of the Constitution, the ratification was as controversial or more so than Obamacare or than passing a budget. But, what you get from standards history books often is that, these are these great intellectual giants. I mean, at times in the Bill of Rights Institute, I have to tell the teachers, because there's a little tendency on the part of the BRI people to engage in what I call ancestor worship. And I said, no, this was very controversial, what they did. And one of the conditions was to pass a Bill of Rights. And you recall that 12 were ultimately proposed to pass Congress and sent to the states, of which 10 passed. One of the ones that didn't pass had to do with the ratio between how many people each representative could represent. And that was that 30,000 number in Article 1 somewhere. And that was just done. But the other one was more interesting. That had to do, well, in a sense, what happened in the first big, during the 1990s, popular anti-Congress sentiment. All of a sudden, a state ratified that amendment from the 1790, all the Bill of Rights came into effect on December 15th of 1791. But all of a sudden, in 1990-something, whatever it was, the state that made it 3/4 ratified that. And people in Congress said, that's dead. This isn't a live issue. This was what became the 27th Amendment, that any pay increase that Congress votes itself will come into effect only after the next election, so we can throw them out if we don't like what they did. This was one of the 12 amendments proposed in 1789, 1790 that was not ratified. And when most people thought an Equal Rights Amendment would become the 27th Amendment, no, this is what became the 27th Amendment. I was telling John I have copies of constitutions that were sent out, pocket constitutions, during the bicentennial. And I just give them to students to have a hard copy. But I cautioned them. I said it's out of date because the 27th Amendment is not in there. That came in the 1790s. So we typically talk about the Bill of Rights as those first 10 amendments. Strictly speaking, they're amendments 1 through 8. But those are the first 10 amendments. Okay, now, questions or comments thus far?
I guess I didn't know all that. I was just kind of curious. So it can kind of just stay put, is what you're saying? Like if it hasn't been passed, it can just last?
Well, see, if you go look at amendments, some later amendments, you'll see they put a clock on them.
Okay.
Right? They'll say this has to be ratified within X number of years. And there was controversy with the Equal Rights Amendment because I think they put in saying it had to be ratified within 7 years, and it wasn't. and they rewound the clock and started it again. Still didn't get ratified, but the people that opposed it put up the hell of a fight, saying that's not fair. It had its one time around. But initially, they didn't put a clock on it. Yeah. Pardon? Early 90s, I think. You remember the Perot in 92? It was part of that whole anti-Congress, nothing's changed. You know, if you go back to the 19th century, Europeans had a phrase, a sociological phrase, if somebody's part of a native criminal class, there's a certain racist element to that. In other words, are you sort of genetically predisposed to commit crime? And they said gypsies were like that and all that. Well, some European happened to ask Mark Twain, does the United States have a native criminal class? He said, no, unless you mean Congress. So, this sentiment has existed for a long time. And we're I don't want to segment tangent, that would be too easy, but, the difficulty is everybody hates Congress as an institution, but everybody loves his own congressman. My congressman's great. Yours ought to be tarred and feathered or strung up. But mine's great. Well, if you multiply that times 435 times, you get a re-election rate of well over 90%. Even though everybody hates Congress. Okay. So we've got this idea of a right that Madison's concern was a kind of parchment barrier. But what does a right do exactly? What does a right do? I mean, you get this, you may talk about this in high school this way. We have a system of majority rule and individual rights. Think of that for a moment. You see anything problematic about that phrase? Sir, you nodded yes. What do you see as problematic about that?
If you have a bunch of individuals, how do you ever get a majority? If the majority is saying this, but all the individuals are countering what the majority is saying. Okay. Push that thought further. That's exactly the right track. Isn't there something contradictory about the phrase majority rule or inconsistent with each other? Majority rule and individual rights. See, if the majority rules, you do what the majority says, even if you oppose that. Right? So, I'm sorry, I think I should be able to drive 75 miles an hour on I-235. Several people passed me on the way down here who evidently had that thought. Okay, but the majority says, and the representatives of the majority say 60 till you get to downtown Des Moines, I'm out of luck. Okay, so if it's majority rule, you're denying that there's an individual right. If you say there's a right, what are you doing? You're saying the majority doesn't rule. Right? If you say majority rules, we say the majority of the elected representatives of the majority will decide speed limits, tax rates, defense policy, foreign policy, things like that. And if you don't like it, it's tough. You've got to go along if you lose, right? But if you say you have a right, you're saying, I get to decide, even if the majority doesn't want to do that, right? So we say in terms of religious freedom, right? The majority can decide what speed limits will be, and I may disagree, but that's too bad for me. I have to go by the will of the majority. But we say that if religious freedom is a right, we say that I have a right to make my own religious choices and allegiances, even if the majority would prefer something else. So that means I decide, not the majority. So when we talk about individual rights and majority rule, in a sense, they're in tension with each other. They're in tension with each other. Right? In actual fact, of course. Oh, good. Okay, sorry. Right. Okay. See, part of the issue is if you expand the domain of individual rights, what are you doing? Then the you're shrinking the domain of majority rule. If you expand the domain of majority rule, you're shrinking the domain of individual rights. Technically speaking, what the Supreme Court supposedly does is police this line. Okay? Now, take the not uncontroversial case of abortion. Right? Prior to Roe versus Wade, let's put an A there for abortion, that was considered to be over here. Something the majority was entitled to decide. Okay? And then in Roe v. Wade in 1973, by 7-2 decision, the court decided there is a constitutional right to abortion based upon various kinds of theoretical underpinnings. We'll get into that issue about rights. And so what the court was saying, well, you know, we've always had it over here, but in actual fact, it belongs over here. Now, there were two types of criticism of that. One was from people who simply oppose abortion rights because they oppose abortion, period. Okay? But the constitutional argument, including from some who favored abortion rights, said, no, you didn't sort of realize that you thought abortion was over here, it's actually over here. What the court did, in their view, was they sort of moved the line and sort of drew it over here. And that's the court's not supposed to do. The court's not supposed to do that. So in other words, our rights are supposed to be spelled out in the Constitution. Neither the legislature can alter those, nor the judicial branch, nor the executive branch on that point of view. But the point is, the tension here is something is decided by a majority rule, you don't have an individual right. You've got to go along with the majority. If something's decided on the basis of an individual right, the majority has to accept that, even if they think something to the contrary. So again, if you got a majority of representatives of Congress who got together and said, we believe that America is a Christian nation and we should say that the U.S. is a Christian nation. There is a Christian flag of America. Has anybody seen that? It's a white flag in the upper left-hand corner. It's a blue square with a red cross in it. And just as there is a Pledge of Allegiance to the American flag, there's a Christian Pledge of Allegiance. This is mostly, conservative evangelical churches. All right? And so if you got a majority of Congress to pass a law saying that, the U.S. is officially a Christian nation, what the First Amendment says, you can't do that. Even though you're a majority, you can't do that. Now, in principle, if you get a supermajority, right, if you get 3/4 of the states, although that may not be a majority of the population because it's done on the basis of states, you can change that. But unless you amend the Constitution, strictly speaking, the majority has to live by certain things individuals decide for themselves because they have a right to do that, even if the majority disapproves. Questions or thoughts about that? Right. Can I, with your permission, defer that? Because that's partly what I'll talk about tomorrow morning in terms of citizenship. Yeah, because I'll talk about the notion of democracy as opposed to the notion of liberal democracy. Okay, there's a significant difference there that's represented somewhat here, but we'll speak exactly to that. I don't want to be left with nothing to say tomorrow morning.
No. Yeah. Sometimes I frame that we have majority rule, but still rights for the minority.
Well, again, number one, technically, individuals have rights. Minorities don't have rights in the sense of a group or something like that in our political system. But yeah, it's just, Madison, you remember Federalist 10? Most people read Federalist 10. And Madison said, okay, how do we create a system? We clearly can create a system such that if some minority, some faction, tries to abuse powers against the majority in a republic, the majority can vote them out. But what if the majority itself abuses powers? By definition, you can't vote them out. That was his concern. Okay. And so that's why they designed the Constitution the way they did. The constitutional design was one part of the answer, so that you can't operate the government in a way to abuse powers. Remember, in the original, let me just note the other way was the sociological solution, the notion of the extended republic. But remember, in the original Constitution, if you think of 4 federal institutions, the House, the Senate, the judiciary, and the executive, only one was directly elected by the people, right? And people in those days meant white male property holders. But that was the House, right? The Senate was chosen indirectly from the people by state legislatures until 1913, the 17th Amendment. The Tea Party movement and Ron Paul, for some reason, wanted to repeal the 17th Amendment. They wanted to repeal that. That's not going to go anywhere. But the Senate now is direct popular election. The president is still elected by electors, right? Not, what we have on November 8th will be a very expensive 51 separate elections going on, but it's 51 separate public opinion polls, so to speak. The actual decision is made 5 or 6 weeks later by the electors. And the courts, federal courts, aren't subject to election at all, as opposed to, say, directly elected judges in some states. Iowa has a nominating commission, but then, as you know, we have retention elections. So in terms of the original Constitution, it wasn't, not many people could vote, and there weren't many institutions in which people's vote, those who could vote, mattered. Yeah.
Could you maybe expand your discussion on, you said minorities don't have rights, individuals have rights, but yet it seems like doesn't the Supreme Court rule on a lot of, for example, in Iowa, same-sex marriage. Mm-hmm. I mean, isn't that protecting a minority group?
Well, it's protecting an individual to make that decision. In other words, that argument is saying, here, same-sex marriage, the idea was here, the people that oppose same-sex marriage, the people who threw out the 3 judges, right, their view is this is something a majority can decide. The state of Iowa had a statute banning same-sex marriage, right? And the argument against that was that that's a decision an individual should make. The state should be neutral with regard to that. So, yeah, I mean, you get collections of individuals who might not constitute a majority, but the right pertains to the individual, not some sort of group, at least in our legal tradition.
Well, I would think, so how do you protect the right of that individual? 2 individuals of the same sex want to get married, yet they can't because
a majority decides. Yeah, again, see, this question is always who decides. Does a majority decide? If you assert an individual right, you're saying the individual decides.
Right.
So, but the key is individual rights versus majority rule. And the question is who decides. Now, typically, there's more than one person involved here, but the point is all those individuals don't add up to this. They don't all add up to this. That's the problem for these folks, right? So, Madison's concern was in a republic you have majority rule, but Madison defines faction. I could pull it up, but it's not worth taking the time. In Federalist 10, saying I think it's a group of people, whether a majority, whether a minority, or a majority, united by some passion or interest adverse to the rights of other citizens or to the community at large. So in other words, for Madison, a majority can be a faction. It's an old-fashioned way of what we might call now special interest, right? And we think of special interest as these small groups. But Madison's saying that a majority itself can be a faction. Right? Look, majority sentiment supported the interning of Japanese Americans in California in World War II. You see issues coming up now with Muslims. Right? So the question is whether, and we talk about democracy, and again, more on this tomorrow, but it's not simply, our constitutional republic is not simply majoritarian. It's this mix of majority rule and individual rights. Now let me shift that a little bit. Listen to this line, which will be very familiar to you, from the Declaration of Independence. We hold these truths to be self-evident, that all men are created equal. I could do 2 hours on the Declaration overall, but that's not what we're here for. That they are endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness. We say nowadays inalienable as opposed to unalienable, as they wrote it. But what's an inalienable right? What's it mean for a right to be inalienable? Can't be taken away. Okay, are you comfortable with that idea? Okay. All right. Well, let's make an easy one in terms of right to liberty. Okay. So if your right to liberty, I mean, it's one of the three: life, liberty, and pursuit of happiness. Although it doesn't say exclusively these inalienable rights that among these. It doesn't say which are the right to life, liberty, and pursuit of happiness. It says among these are life, liberty, and the pursuit of happiness. Let's take liberty, right? So if a right, if to say that our right to liberty is unalienable, means that it can't be taken away from us. How can the government imprison somebody? Okay, but you're saying with the right procedures, with the correct procedures, that right can be taken away from you. But the point at the beginning was, if it's an inalienable right, it cannot be taken away from you. So what's it mean, unless it's gibberish, I don't think it is, what's it mean for a right to be inalienable? You all are teachers, aren't lawyers. I was at a conference once sponsored by, and I'm not a lawyer, by the American Bar Association. And I asked a guy, it was on having to do with religious freedom, a fairly innocuous sounding question. I just said, what year is this? And trained as a lawyer, he immediately got suspicious, right? And wasn't going to answer that until he got more. So you all didn't get immediately suspicious, but you're okay. You're not trained as lawyers. My students say to me, why did you go to law school? You've written 2 books on the Constitution. I would say, I give you 5 quick reasons: torts, contracts, property tax, civil procedure. I'm glad somebody learns that. I don't want to learn it, but I'm glad somebody does. So is it gibberish to talk about an alienable right, or you're saying it can be taken away with the right procedures. But that begs the question. That assumes it can be taken away. But to talk about an inalienable right means it can't be taken away. So how else can we work through that conceptual muddle? Yeah.
It has to do with popular authority, social contract, large groups of people, the liberties of the people that agree to this can't be taken away.
But if you can lock anybody up, go slug a cop or do 100 on the freeway or rob a bank, you can be locked up. Aren't they taking away your liberty? Okay? So how do we have an inalienable right to liberty? And whether you know it or not, I just left you a clue.
You took someone else's rights away.
Pardon?
Because you took someone else's rights away by slugging them.
But see, now you're saying your right's not inalienable. We can take it away if you deserve it. Right? So you're just justifying it. You did in terms of procedures. You can take somebody's rights away if you follow the right procedures. And there's some truth to that we'll get to. You're saying you can take somebody's rights away if he's done something to surrender or forfeit them. He deserves to lose it. But that still begs that question. But if it's an alienable right, by definition, it cannot be taken away. So how do we deal with that? The answer, at least as I would say it, thinking in terms of this example of our right to liberty, and you have to think about it for a moment when I tell you. Government can take away our liberty. What government cannot do is take away our right to liberty. Now, what would that mean? If I'm sitting in jail, it's nice to say I have a right to liberty, but I'm still in jail. So what's going on? What does having the right to liberty do? It's connected with your notion of due process or your notion of deserving it, right? What precisely is inalienable?
As long as we follow the social contract, then our liberties are, I guess, more guaranteed.
Okay, so turn that around. If you don't follow, government's claiming you haven't followed the social contract, right?
You've lost your inalienable right.
No, you haven't lost your right to liberty.
You've lost
Your liberty,
yeah.
right? In other words, this sounds like wordplay, but it's not. It's really important. To say that we have a right to liberty doesn't mean the government can't take away our liberty. It says government may take away our liberty only if it gives a good reason for doing so. That's what it means to have the right. The government has to give you, and in your eyes it'll never be good enough, but it's got to give you and the public a good reason for taking away your liberty. So what the right to liberty gives you is not your liberty per se. It guarantees you that government can take away your liberty only by giving you a good reason for it. That's what's inalienable.
This seems like the crux of when we have the argument with students over, in school speech, we can take your free, or the right to, we can take your speech away, but not your right to free speech.
Okay. But then, how would you pursue that with the student? I was going to mention, you're familiar, I'm sure, with the Tinker case and the Hazelwood-Kuhlmeyer case, right? Those are great cases to talk to students about because it has to do with high schools. In other words, you can not allow them to publish whatever at Hazelwood. You can, the armband issue, which raises some other issues I'll mention momentarily in terms of the problems in dealing with rights. But what the students basically are demanding, and what you're thinking they have a legitimate right, if you will, to demand, is that you give them an explanation. Right? How many of you, and you're all younger than I am, but how many of you have seen any of these old movies, these sandals and sword, blood and things with Roman colosseums and gladiators and everything? Have you ever seen the picture of the emperor's lying up there above everybody, and the girlfriend's feeding him the grapes, and the gladiators are fighting down there, and one finally gets the other down, and he's got the sword at his throat, and he looks up at the emperor. And, shall he live or shall he die? And, the emperor might sort of do this and that, whatever. What do we call that when the emperor makes that sort of decision? That's pure what? It's arbitrary. It's pure whim, right? Right? Well, to say that a right to liberty is inalienable means, going back to your point, it can be taken away only in accordance with due process. So in that sense, your right is to due process, not to your liberty per se, but the thing that's your right's to your liberty, but what's inalienable is the due process that's required. That can't be taken away from you. So your liberty can be taken away on certain conditions. You violate the social contract, you break a law, you kill somebody, whatever. But that's why we have a trial. That's why, despite popular literature and films and everything to the contrary, we don't say, let's give him a fair trial and hang him. Right? That's the denial of due process. So what's inalienable is not your liberty, and death penalty states it's not your life. What's inalienable, because they can take your life, they can take your liberty, they can take your speech, right? What they can't do is take away your right to be given a good reason. That's what's inalienable. Does that make sense? Because technically, if you've ever dealt with small children, whether it's a teacher or a parent, at times you try to reason with the little kid, and then what finally, when that doesn't work, what do you finally say? Because I said so, or because I'm your father, or because I'm your mother, right? Government supposedly is not to do that. to say ultimately, I'm sorry, it's because I'm the government. No, government has to give us a good reason. That's what's inalienable. So they can take our liberty. What they can't take is our right to liberty, which means they've got to give me a good reason for taking away my liberty. That's what it means to say that the right is inalienable.
Doesn't that also presuppose that if you're right, or if it's taken away from you, once that circumstance is changed,
They have to give it back to you.
right.
Yeah.
So,
Yes.
so, for example, if your justification is in a school building, it's not appropriate for students to either stay or do or wear certain clothing because of the nature of the special place. But once they leave the school building, they retain that right of free speech or symbolic speech. So by extension, then, if someone has their liberty taken away, put in jail for committing a crime, once they serve that penalty, shouldn't all of their rights automatically be, because they never lost them, be restored? And yet, here in this state and in some other states, we have this situation where you actually have to apply to get your voting rights back. But so how does that happen?
Well, I don't think that guarantees you get your right to vote back. I mean, you can take a position for or against that. The key thing is, how good of a reason does the government give you for not returning your voting rights to you? Right? I mean, can the government legitimately, acting on behalf of the majority of the people, say that you committed a crime of such a nature that you will serve part of the punishment is you forfeit your right to vote? Okay? Permanently.
Even after you finish
Yeah, but presumably they give you a reason. Now, you could argue the reason's not very good, okay, but they give you a reason. But see, that's what I think is the inalienable part of inalienable rights. They have to give you a good reason.
So the onus is on
the government. Yes.
To provide what that reason is.
Exactly. And
then is it up to the majority to determine whether that's a valid reason or not?
well, not in the immediate case. I mean, they can change the law, right? But you remember, if you watch the Republican convention, I'm just thinking, if you watch Chris Christie at the Republican convention, when he was a prosecutor, and he sort of gave this bill of indictments against Hillary Clinton, and I'm not taking any partisan position here. What I'm taking exception to is what he did in those circumstances. And he'd say to the crowd or the mob, guilty or not guilty. This is like a show trial in a dictatorial country. That's not due process, right? That's not, let's give him a fair trial and hang him. In other words, that's letting the majority decide. See, because one of the issues when you talk about the courts, which we use to safeguard rights, there was a phrase in one of the ads in the retention vote of 2010, and again, this is independent of the merits of the same-sex marriage decision. But the argument was these radical, out-of-control judges are ignoring the will of the voters. And I did a course called Constitutionalism and Democracy after that, keying off of that whole issue and exploring that issue. And I said, any judge listening to the will of the voters is not doing her job as a judge. Because what the judge represents is not the voters, the judge represents the law. Now, the voters ultimately at some point can change the law, but the judge's obligation is to the law, it's not to the popular passions of the moment. That's why at the federal level they're not subject to electoral recall or election of any sort. I believe, what was his name, Lance Ito in the OJ case in California, wasn't he an elected judge? And there was this question of what's he going to decide if he wants to, there's electoral pressures, but you want to keep your judgeship. Are you going to vote the way you think? And there was some study, I don't know if it was the ABA or somebody else just came out with, that lengths of sentences or severity of sentences increases as you get close to election time, where judges are elected. Okay? Well, should that be the case? But the judge is supposed to represent the law, and the law is supposed to provide this due process. Okay? I wanted to note parenthetically from what you mentioned, the courts are remarkably deferential about protecting rights. In other words, they're less likely to have a full-throated protection of rights. In 3 institutions, and the grouping is interesting. Prisons, the military, schools. Right? Courts are much more deferential toward the forces of law and order, so to speak, prisons, military, and schools, than to individual rights. So if you've got this idea of what's inalienable, the government has to give you a good reason. The question is, how good of a reason does government have to give if it wants to take away a fundamental right, say religious liberty or something like that? We hear a lot about that now. Okay? And I've got to introduce a legal term, where I'll try to domesticate it. It's called levels of scrutiny. Levels of scrutiny. And there are 3 levels of scrutiny. In other words, what it has to do is how good of a reason does government have to give? My argument, in other words, is that despite words to the contrary, I don't think any right is absolute. The question is always, how good of a reason does government have to give in order to infringe upon that right or take that right away? There is no absolute right. You know, the classic case you get is the guy who knows where there's a ticking nuclear device in Central Park in New York. They're not going to read him his Miranda rights. Right? Now that presupposes you're going to get a truthful answer. If you're torturing someone, studies tell you anything you think you want to hear, whether it's the truth or not. But still, you get that particular case all the time. The Supreme Court created, this is not listed in the Constitution, but it's a rule of thumb, or it's a set of rules the Supreme Court created to this idea of levels of scrutiny, to define how good of a reason the government has to give if it wants to restrict a liberty. Okay? Now, the lowest level of scrutiny is called the rational basis test. It's a really low bar for government to have to get over. And usually the plaintiff has the burden of proof. The rational basis test says the law in question has to be reasonably related to a legitimate state purpose. The law in question has to be reasonably related to a legitimate state purpose. Okay, so I have what the court would call a liberty interest in driving as fast as I want on I-235. But the rational basis test, that lowest level, my right doesn't survive that. Because they say government restricting my right to speed as much as I want is reasonably related to a legitimate state purpose, protecting people's safety. Okay? This is also used for economic legislation. So that's the lowest level of scrutiny, the rational basis test. The law's got to be reasonably related to a legitimate state purpose. And the burden of proof really is on the individual, the plaintiff, to say that the government's law is not reasonably related to a legitimate state purpose. The next level up, and a majority of the courts never really bought this, a plurality did, but it's a tricky issue. It's called, the sexy name, intermediate level scrutiny. Intermediate level scrutiny says that government, to limit or deprive you of the right in question, government has to demonstrate that this is substantially related to achieving an important governmental purpose. So limiting your right in question has to be proven to be substantially related to an important government purpose. You see how that's a little tougher on both sides. It's not just reasonably related, it's substantially related. And it's not just a legitimate state purpose, it's an important state purpose. Okay? That's intermediate level scrutiny. That really originated in equal rights cases having to do with women. under equal protection. There was a case, I think not Reed versus Covert, Richards, who am I thinking of? It's from the 60s. A woman service person, can't remember which branch, I haven't read it in a long time, brought suit because she applied for benefits for her husband who was not in the military. And if a male service person applies for benefits for his wife, it's granted automatically, at least it was then. But for the woman, she had to demonstrate that he was dependent upon her for his living and his expenses and all this and that. In other words, she had a higher bar to clear than the male service person did. And the court found that that violated the equal protection provision in the 14th Amendment. And that's a wickedly complicated dimension of law, equal protection law. But a plurality of the court said that this was the government had to show to justify this that it was substantially related to an important governmental interest, and the majority of the court said government couldn't do that. Okay. What's the third level, the highest level that's of most direct relevance to what we're talking about, is called strict scrutiny. Strict scrutiny. Under strict scrutiny, the government must demonstrate that limiting or depriving you of the right in question. Again, the government must demonstrate that limiting or depriving you of the right in question is necessary to achieve a compelling governmental purpose or state interest. Government must demonstrate that limiting or depriving you of the right in question is necessary to achieve a compelling governmental interest or purpose, whatever word you want. So you see, instead of reasonably related or substantially related, it's necessary. And instead of legitimate purpose or important purpose, it's a compelling governmental interest. Okay? So you have these three levels of scrutiny. Typically, everybody always asks, what triggers strict scrutiny? Again, intermediate level doesn't show up that often, except occasionally in equal protection cases. Normally, lawyers will tell you that if the court announces the right test as the rational basis test, the government always wins, or almost always wins. But if it's strict scrutiny, the government almost never wins. Right? Well, what, as the phrase goes, what triggers strict scrutiny? In other words, this is the strongest reason. Remember, to have an inalienable right means the government must give you a good reason. And the courts say in cases of strict scrutiny, in these instances, the government's got to give you a damn good reason if it's going to infringe upon or deprive you of a particular right. Okay. Well, what triggers this level of good reason, this powerful of a good reason? Two things. One, the term is suspect classifications. Suspect classifications. Right? And the most famous or infamous one is race, given our history. So if the law in some way makes racial distinctions, that immediately, because of our past, triggers strict scrutiny. If you're going to deal with race, you've got to, in some way, you've got to show that it's necessary to achieve a compelling governmental interest. Okay? This was the issue in the affirmative action cases the courts had recently, right? And the question was is diversity a compelling state interest that would justify affirmative action? And for the most part, the majorities held that it is. That may not last, but that's what the courts argued. So, suspect classifications, the key one is race. The other broader thing that triggers strict scrutiny is fundamental rights. If the government is acting in a way that infringes upon or deprives you of a fundamental right, that triggers strict scrutiny. So in other words, government's got to give you a damn good reason for doing that. Let me take the case of religious liberty, because we hear that a lot now. Okay? There was something I picked up today. It was in the Atlantic online. not an unprovocative title, when religious freedom leaves children dead. Okay, religious freedom, free speech, free press, all these are considered fundamental rights. See, that's part of the argument over abortion. The conservatives on the court say a woman's interest in having a right to an abortion is a liberty interest, just like wanting to speed. But they say that triggers simply a rational basis test. Whereas the people defending abortion rights say, no, that's a fundamental interest, which would trigger strict scrutiny. Okay. Well, religious freedom is considered to be a fundamental right. And in 1990, there was a case called Employment Division of Oregon versus Smith. Two people, interestingly, they were working for the Unemployment Division in Oregon, and they were fired for smoking peyote. And they applied for unemployment. That's the irony of the whole thing. And were denied it because it contravened an Oregon law, controlled substances law. Right? And Smith and the others appealed on free exercise grounds. They wanted an exemption from this law because they said, we weren't just trying to get high. We're Native Americans. In our faith tradition, this is just as much of a ritual as drinking wine at Mass. Okay? Or blessing over wine in Jewish tradition or something like that. Okay? And so they wanted an exemption from the law because of their religious freedom, for religious freedom. Justice Scalia wrote for the court, respondents in the present case, the guys, the Native Americans, contend that their religious motivation for using peyote places them beyond the reach of a criminal law that is not specifically directed at their religious practice, and that is concededly constitutional as applied to those who use the drug for other reasons. They assert, in other words, that prohibiting the free exercise of religion includes requiring any individual to observe a generally applicable law that requires the performance of an act that his religious belief forbids. As textual matter, we do not think the words must be given that meaning. He continues, conscientious scruples have not, in the course of the long struggle for religious toleration, relieve the individual from obedience to a general law not aimed at the promotion or restriction of religious beliefs. The mere possession of religious convictions which contradict the relevant concerns of a political society does not relieve the citizen from the discharge of political responsibilities. And he quotes the case of Reynolds versus United States from 1879. That was the polygamy case. Okay? It was one of the first free exercise cases. He said, and quoting the case, can a man excuse his practices to the contrary because of his religious belief? To permit this would be to make the professed doctrines of religious belief superior to the law of the land, and in effect to permit every citizen to become a law unto himself. Okay, so if I were late coming down here and got stopped and the officer said, you've blown past the speed limit, here's a ticket. Sorry, officer, God told me I had to be here on time. And if it's you or God, I'll go with God. You can go back and read Sophocles' Antigone from ancient Greece dealing with that issue. That's as old as it is. Okay? So, to what extent can religious belief trump, no pun intended, a law that seems to infringe upon it or restrict it? And see, in this particular case, let's see. It's a girl had a swollen shoulder, not just swollen, it was bone disintegration, a serious medical condition on X-ray. She and her mother didn't show up at the hospital when a chiropractor had urged them to seek medical care. Instead, Jessica, the girl said she chose to turn to, quote, Jesus Christ, my Lord and Savior, my healer, defender, for Jessica's healing. Or that was the mother. Crank, the mother, knew there was a problem with the grapefruit-sized tumor on her daughter's shoulder, but she believed Jesus was the only healer, she said. And through that belief, we took it in our hands to pray for her, to heal her with prayer. It did not work. After the walk-in clinic nurse called the police and Jessica was taken to the hospital, she was diagnosed with Ewing's sarcoma, a rare form of cancer. She died in state custody at the age of 15. Okay, and the parents were found guilty of misdemeanor child neglect. They said it was their religion, right, that entitled them to supersede the law. And Scalia is saying here, basically the court said in this case, if a law is generally applicable and not targeting a particular group, then everybody, regardless of religious convictions, is subject to it. So in other words, what this case of Employment Division Smith did, in effect, was reduce the protection of religious freedom to that rational basis test. If the law is reasonably related to a legitimate state purpose, then it'll stand. Well, this made people across the political and religious spectrum, from very liberal Jews and Protestants and Catholics to very conservative evangelical Protestants, it made them very nervous because they thought this completely undermined the strict scrutiny that's necessary, the good reason you have to give for infringing upon a right. So this alarmed people tremendously. That's what led to the creation of, you've heard RFRA, right? Religious Freedom Restoration Act. The feds passed one in '93. Some states have passed it. But this is where, it's what we hear, the law said that in these cases, the appropriate standard is strict scrutiny. So they tried to bring this back to say, if you're going to infringe upon somebody's right to religious liberty, you've got to give a very good reason, necessary to achieve a compelling state interest. And so you get, what was her name, Kim Davis in Kentucky, right? She wanted to say, she said, quote, to issue a marriage license which conflicts with God's definition of marriage with my name affixed to the certificate would violate my conscience. So she was seeing an absolute protection of her right to religious liberty. But as I said, there are no absolute rights. It's just the level of scrutiny. And so when we talk about protecting an individual right, if it's going to be a fundamental right, and of course that's part of the issue, is it a fundamental right or not? As I said, abortion opponents, right to abortion is a liberty interest, but not a fundamental right. The opponents of abortion rights say, no, it's a fundamental right. But if it's a fundamental right that triggers strict scrutiny, which means government's got to pass that test that says that it's necessary to achieve a compelling state interest. And so, as I said, for the most part in schools, it's a version of the rational basis test. Yeah, freedom of speech for us outside may be a fundamental right, but for kids, there's you could argue that restricting student speech is necessary to achieve a compelling state interest in terms of fostering education and protecting the schools. Or you could say it's simply a rational basis test. It's reasonably related to achieving a legitimate state interest, maintaining order in schools. So the question is always, with regard to a right, then, how good of a reason does the government have to give you? And the toughest bar to that, the toughest level of that, again, is so-called fundamental rights. And that's what strict scrutiny. Questions or comments? It's a lot to swallow. Was it Justice Jackson, I think, who famously said the Constitution is not a suicide pact? So, you can assert all the time that rights are absolute, but they're not. That may not be comforting, but it may be comforting. It depends upon your point of view.
My brain's always kind of thinking about this in two aspects. It's interesting for me just to think about it, but I'm also thinking about my students and how to work this, in my teaching. So what would be your opinion on, what would you think would be essential for students to understand about this, I guess, in general as a citizen, and then for students who are going to go on to college who you work with, what do you want them to come in with?
Well, Is it cheap to say what I just said? In other words, I mean, the idea that I would quiz them, and again, your specialist in the classroom tomorrow or later tonight will talk more about how to operationalize this. I don't know how to do that with high school kids. But again, I think to focus on this notion of what it means to speak of an inalienable right, as I've said, also to problematize, if you will, the mindless phrase majority rule and individual rights, as I try to do for you, and then to focus on this notion that rights aren't. That's why I put it in terms. I introduced the technical legal terms, levels of scrutiny, but I began it by a more everyday phrase. To say that the right is inalienable means government may deprive you of a right if it gives you a good enough reason. So how good of the reason does the reason have to be? And that's how I distinguish between levels of scrutiny. So again, government doesn't have to give you as good a reason to limit your speed on I-80 or 235 as it does to limit your freedom in terms of religious expression or free speech or things like that. Because they'll also, driving's a privilege. It's not a right. That's why it's also a rational basis test. So I would focus on that. Because, Scalia's point was that, again, if you say that rights are absolute, what that essentially does is shove this line all the way over here. It makes everybody himself his own law. I'm sorry, my God tells me I can't do that. It's what our mothers told us when we were little. What if everybody said that? That's Scalia's point. Right? You can't have a functioning society. But Scalia worried religious groups because, again, they thought he took away the notion of religious liberty as a fundamental right. You're saying it's just a liberty interest. As long as the government's not targeting you, there was a case having to do the Hialeah case, Lukumi, Lukumi, in Hialeah, Florida. That was a case where a law banning certain kinds of slaughter of animals for religious sacrifice. That really was targeted at this particular group. And the court struck that down. But the Smith decision was, if the law is not targeted at some particular group, then everybody has to obey it, regardless of your religious convictions to the contrary, if it's generally applicable and not targeted at a particular group. So again, the RFRA idea was to try to give people some basis for, again, Justice O'Connor and others in the sense that Scalia just let the air out of the whole idea of a right to religious liberty. And so the RFRAs were supposed to recreate that compelling state interest test, the strict scrutiny test, to give it a little more oomph. Scalia's judicial philosophy really was one, say, it was more that you protect against abuse of power structurally. The courts really shouldn't be involved in protecting rights very much, although he would show up at times and protect the oddest things. I can't remember the name of the case. There was a case involving a thermal imaging machine. You've heard of that one at all? Some guy was suspected of growing pot in his house, which generates evidently a great deal of heat. And they set up this thermal imaging machine outside the house, which is, I guess, a version of infrared, and it glowed all over the place, suggesting all this heat's being produced there. And so they went in, and then they claimed it was an illegal search and seizure. And Scalia actually struck down that police action.